Hello, welcome to Trump 47 Watch. Today's episode focuses on the U.S. Supreme Court ruling on July 8th, allowing for the reductions in force of federal employees to continue while the courts consider the merits of the case. I'm Merrick Masters, professor of business, commentator, podcaster. You can find me at my YouTube channel. My email address today is July the 10th, 2025. I provided you here a summary of the case history, which was filed by the American Federation of Government Employees against President Trump for issuing an executive order and subsequent agency guidance to agency directors to begin implementing reductions in force on a wide scale. As it says here, on July 8th, in an 8-1 decision, the Supreme Court stayed the temporary injunction that was granted by a lower court from implementing widespread reductions in force in agency reorganizations across 22 agencies. The executive order, here's a little bit about it and where you can find it, concerning reductions in force, urges agency heads to promptly undertake preparations to initiate large-scale reductions in force consistent with applicable law, and to separate from federal service temporary employees and others that work in areas that will be subject under this order to RIFs. The guidance issued by the Office of Management and Budget and the Office of Personnel Management on February 26, 2025 states that the principles to inform these agency reduction in force plans should seek to achieve the following: better service for the American people, increased productivity, a significant reduction in the number of full-time equivalent positions by eliminating positions that are not required, through a variety of actions, including reductions in force, terminations of probationary employees, closure of agency units, and also reduction in force plans that have been implemented so far. The administration has impacted hundreds of thousands of federal workers, although the exact extent to which all of them have been reduced in force or forced to stay off work is in question, because the courts have at many levels decided that these requirements, these reductions in force and other actions, were unlawful. Until the Supreme Court eventually resolves this, we'll be in a state of limbo on the status of this, as there is no central repository of actions taken by the federal government to reduce the workforce. The Supreme Court ruling, here's a little bit from the statement. It was a brief statement issued in an 8-1 decision, says that because the government is likely to succeed on its argument that the executive order and memorandum referred to above, and because the other factors bearing on whether to grant a stay and of the temporary restraining order are satisfied, we grant the application for staying the temporary restraining order. The court went on to say, we express no view on the legality of the agency reduction in force and reorganization plan produced or approved pursuant to the executive order memorandum. That will have to await until agencies propose their own plans, which then become the subject of review based on the merits. I hope you've enjoyed this presentation. I'm Merrick Masters. Stay tuned for more continued news on President Trump administration, particularly in the area of federal sector personnel, labor relations, and organization. Thank you and have a good day.